Good afternoon, everyone. Welcome. Today is Thursday, October the 17th, 2024, and this is PACO's Workers' Compensation Roundtable. Before we get started, I'll make a couple of brief announcements. First of all, let's see. On October the 31st, see, I've got the wrong week's notepad up. Let's see, coming up, on October 31st, Brady Grove, an attorney with Hornstein, Nicholson, and Blumenthal, is going to present a program about the essentials of VA disability benefits, including the criteria and process for establishing a service connection, the VA's organizational structure, and its impact on claims processing. He'll also address issues such as military sexual trauma and health implications of toxic exposures such as Agent Orange and burn pits. Registration is open on the website. If anybody's interested in signing up for that, please do. Also, your OSBA paralegal certification, if you are interested in sitting for the exam, which will take place in May 2025, this is the time to start planning for that. We have already kicked off our certified paralegal, the certification exam study group, and that study group will meet again on Monday, October 21st. At 6:30 in the evening by Teams. And there's information on the website under news to email Randy Daniels Blair if you're interested in attending that. Also, if you already have your OSBA certification and you are in your biennial year for reporting and renewing, applications are already live on the OSBA website to go through that renewal process. Those applications opened, I believe, October 1st, and they will be open through December 1st. So go ahead and get your renewal started. The PR committee is meeting again on October 30th. We are going to continue planning the upcoming holiday happy hour and also Paralegal Day in May. We're also working on trying to get together a evening at the Columbus Blue Jackets, which sounds really fun. If you would like to help out with that committee, again, reach out to Randy Daniels Blair. And I think that is pretty much all I have as far as announcements. So let me go ahead and introduce today's speaker. Joining us today again is John Bauer. He is an attorney with Polling. John's primary focus is defending self-insured and state-funded employers before the Ohio Industrial Commission, as well as in state courts on appeal. During law school, John worked on the legal research team at the Ohio Industrial Commission, so he knows his way around the Industrial Commission. While there, he learned how hearing officers make decisions, and now he uses that knowledge to his client's advantage. John is a very practiced and skilled workers' compensation and litigation attorney. He has a very good track record, and we are very glad to have him here with us again today to talk about loss of use awards. Welcome, John.
Great. Thank you for the introduction, Angela. I appreciate the opportunity. Like she said, we're going to talk about scheduled loss and loss of use compensation. I have a presentation planned. I'm planning on showing you specifically and practically the medical evidence that's required when asking for or defending against these rewards, the timing of when these applications should be filed or when you should defend against the filing of them, and then also get you a feel for the dollar amounts of the awards in these claims. That's my plan, but I would always rather talk about something that you're interested in than what I am interested in. And so if you have any questions, if there's anything you want to talk about, I can hear myself talk all day, every day. And I would rather hear you talk and talk about what you want to do too. So going to the first slide here, we have scheduled loss of use awards. These come from Ohio Revised Code 412357B, and scheduled loss awards or loss of use awards are for specific parts of the body due to an industrial or occupational disease. And we have a table in the coming slides that show why it's called a scheduled loss. It is just a body part next to a number of weeks that are given for that body. And so it's compensation for a specific scheduled bodily loss. It's not wage loss compensation. It's payable regardless of work or other compensation. It's more like a damages award. And the loss can be by amputation or loss of use, including ankylosis or stiffness of a joint. And typically these awards are initiated when a motion is filed by the injured worker. If the employer agrees with the scheduled loss, they can file medical evidence that designates the exact point where the amputation or ankylosis or loss of use occurs. They can file that with the BDWC. There's a specific C196 loss of use diagram for hands in particular, and I'll show you that in a little bit. And so if the employer doesn't agree with the award, they dispute the award, and it would get scheduled for an industrial commission hearing to process and address the award. On the next slide, we see that the loss of use doesn't need to be absolute in the case of a loss of use rather than an amputation. And there, an award for loss of use is appropriate where the injured worker has suffered the permanent loss of use of an injured bodily member for all practical intents and purposes. But the legal standard doesn't require that the injured bodily member be of absolutely no use in order to establish eligibility for a loss of use award. And so this can get to be complicated and disputed. And so in one particular claim that comes to mind, we have a doctor for the injured worker who says they've lost use of their body, their hand for all practical intents and purposes. We have a doctor who did a report for the employer who says, well, it's not absolutely of no use. And they're both saying things that could be true, and the award could still be made anyway. So oftentimes what this can come back to is look at the job description and whether the injured worker would be capable of performing the job function with their injured part of their body in the state that it is post-injury. And so when I have a claim like this and when I want to say from an employer's perspective that the hand can be used for practical intents and purposes, I'll upload the job description, I'll have the reviewing doctor review it, and I would want an opinion saying they could perform the job with the hand or whatever part of the body has been injured. On the next slide, then thinking about the payment of these awards, the payment is made in weekly installments for a scheduled number of weeks of compensation depending on the bodily members at issue. And the amount of money that is paid is not based on the individual injured worker's average weekly wage, but it's based on the statewide average weekly wage for the year when the incident occurred. And so does anyone know what the statewide maximum is for 2024?
No idea.
I'm pretty sure it's 1,195. And so if you want to keep that number in mind for some calculations later, you don't go to the individual injured worker's average weekly wage. You use that statewide maximum instead. So let's take a look at the next page here. We have the number of weeks for each body part. And as you can see, it just seems kind of callous, like you've lost an arm, so it's 225 weeks and on down the list. But there are a few things about the scheduled loss to keep in mind that are different for each body part. So an amputation above the elbow results in an award for the loss of the entire arm. And so there's no such thing as an award for a partial loss of arm. And the same with an amputation above the ankle but below the knee is a loss of the whole foot but not the leg, while if the loss of a leg is payable, the injured worker would get paid for both the loss of the foot and the loss of the leg. And so those two numbers would be combined. So this number
Okay.
here, just for your reference,
John, I'm
if we
sorry.
go to yeah.
We do have a question, Connor, if you'd like to go ahead and ask your question.
Yeah, can you hear me?
Yes.
Okay, sorry. Yeah, sorry to interrupt. But I know John was saying before, for 2024, the maximum rate, is that for TTD that you were talking about?
Yes.
I think for 2020,
Do I have it wrong?
is it 1195?
It is. It is.
Okay.
I've got my
I
chart
believe-
and that is correct.
Okay. Okay.
So that is
Yes, and so I have
to clarify, that is the maximum
Yeah.
that anybody can receive per week. So if their wage calculations come out to be, $3,000 a week, they're capped at $11.95 for the year 2024. But so not everybody gets $11.95. That's just the cap of what it can be.
but for loss of use, everyone gets that amount. So if we look at the next page here, we have an example, I believe. Do I have an example on the slide or not? Yes. And so if the injured worker's average weekly wage rate would be $7.50 and the statewide maximum is $11.95 for the year, and they lost their pinky finger, they would get $11.95 per week for those 15 weeks for their scheduled loss award. And so depending on which side you're on, if you're an employer and their average weekly wage is smaller than this, then you pay more for this and it cuts against you. If it would be $3,000, like Angela was saying, it would be $11.95 per week for the purposes of the loss of use award too. Does that make sense? And
Yes,
so
I think
it's
so.
an interesting calculation. Okay. And so a situation that could come up is, in this example we have here, someone lost their pinky. And I'll just open this up. What do you think would happen? What do you think would happen if someone lost their pinky and it was successfully reattached? Would they get an award for the loss of use of their pinky?
Depends
What would it depend on?
whether they have any functional use of the pinky. Just because the
Yeah.
pinky's been sewn back on, if there's no functional use of it, they could be eligible for an award.
That's right. And so if they lost their pinky and it's reattached and it's successful and it's working too, they may not be eligible for the award immediately. But if it started to lose function, like Angela was saying, and if over time it didn't work anymore, then they would be eligible to file for an award for loss of use compensation for that finger later.
So that's if
Paul,
it's, oh, sorry, I was just gonna, so that's if, say for instance, that body part, the pinky, so that's if it's reattached, but they have either limited use or no use of it?
So generally when a finger is amputated, it's an immediate scheduled loss award for the number of weeks that was on that chart. If the amputation occurs and it's reattached, and if it's successful, then generally there would be no need for a loss of use award. Okay. But if then the finger subsequently or body part wasn't working properly and they needed to file for an application for loss of use, they would be able to do so. You're not barred from being able to file it in the future simply by having an amputated body part reattached. Any other questions while we're here? All right, so we're going to go through more specific body parts and considerations for each one. So up first, we should have a slide about loss of vision next. And the computation of permanent partial loss of sight of an eye is paid on the basis of the vision actually lost by the particular individual and not based on a percentage computed on a hypothetical scale of normalcy. And so you look at a person's vision before the work incident and decide the percentage of vision that was lost. And so you're looking at, again, that the key term is the percentage of vision lost as opposed to whole person impairment as a result of the loss of vision. And so you are required to have an ophthalmologist as your medical expert to get a loss of vision award. And what the ophthalmologist will do is they will compare your vision after the incident to your actual vision before the injury and determine the percentage of an award that you are entitled to. So I have a couple examples. So if an injured worker had lost 75% of their uncorrected vision from before to after, they would be entitled to a 75% award for loss of partial vision. And the minimum award is 25% for loss of vision. We'll come back to that in just a second. And so it doesn't matter if you get cataracts or corneal transplants or any other more significant surgeries to your eyes as a result of a work incident. What we're looking for the purposes of loss of use is the vision you had before compared to the vision you had after. And so I think that I have an example on a slide here. But yes, and so we'll do this example first, then we'll do one more. And so again, we have the injured worker's average weekly wage is $750. State maximum average weekly wage is $11.95. Right eye, 45% loss of vision. Left eye, 55% loss of vision. And so we do the 125 weeks for a loss of vision or a loss of an eye times 45% for the loss of vision. We get 56.25 times the 1195, and we get that 67,000 number. And then for the left eye, when we do the same percentages there, we get 82,156.25. I have a couple of follow-up questions, but does that make sense? I think I have maybe one more example that can help crystallize this. So let's say that you have bad vision before a work incident and you only have 20% vision. After the work incident, your vision is down to 5%. And as you can tell from how I'm saying this, you need an ophthalmologist to be your expert, because I'm sure the way that I'm saying this doesn't even make sense. But you've gone from 20% vision down to 5%. That would be a 75% reduction in your vision, and you would be given a 75% award. You would do 125 weeks times 0.75 times 1195 for 2024, and that is how you would get the amount of your award. Now, in this example here, I think the number's like almost $150,000 for about 50% loss of vision in both eyes. And so I just want to raise the question: what do you think of this setup? Do you think that's a fair compensation for loss of vision? Or really anything that we have on the scheduled loss sheet. What do you think of the idea of getting paid out weeks of compensation for 15 weeks for a pinky? Would anyone want to get paid 15 weeks to give up their pinky?
I don't think I would.
No, right? Anybody else? Look at this chart again. I don't know if we can go to the slide, but arm 225, leg 200. So you get paid about 4 years of compensation for losing an arm or a leg. That doesn't seem like a very good deal. And so
No,
again,
especially if you're, 20, 25 years old and you're looking at, potentially another 50, 60 years of life that you're going to have to go without that body part. That doesn't sound very good at all.
Yeah. And so whenever I talk about workers' comp and the system that we have, I like to talk about how it's a compromise between employers and their workers. And as part of that compromise, both sides are giving up certain rights and incur certain obligations. And so before we had the workers' comp system, if someone lost their arm or a leg or any of the body parts that we were talking about here today, they would have a right to sue their employers for negligence on the job. And those types of lawsuits would be huge amounts of damages, like Angela was saying, like a young person cuts off their arm there and their employer was negligent, that could put the business at risk and they would need to possibly be at business or they would get no compensation for their loss. And so this is where we've landed in our compromise. And I, like Angela said at the start, I typically represent employers, and if their employee has been negligent and lost vision and may be entitled to an award of $150,000, they generally do not want to pay that $150,000 to their negligent employee. So I often remind them that this is a compromise, the system we've agreed to, and that they have given up their right to sue to have these employees, and that they're not getting fully compensated for their loss of their vision either. And so just thinking about, I always enjoy thinking about how these things fit into the larger legal framework and what's going on. And I think it's an interesting compromise to think about getting paid in this way for your injury that you have at work. All right, we can go on to the slide about loss of hearing next. Little down past, yes, thank you. And so partial loss of hearing is not compensable. An award can only be granted for permanent and total loss of hearing in at least 1 year. And a loss of hearing award requires medical documentation from an ENT, a near nose and throat doctor, except when the injured worker bases the loss of hearing on psychiatric factors. So
I'm sorry, John, did you
the
say
reason
on
that-
psychiatric factors?
Yes, and I'm not exactly, I have never seen that happen in a claim, but apparently where someone
Like a
has
hysterical
physical,
loss of hearing?
yeah, so
Okay.
you must have to have a physical injury at work that leads to a psychiatric condition that then leads to a loss of hearing. And in those situations, they wouldn't require an ear, nose, and throat doctor to be the expert providing that documentation.
So
Interesting.
is that almost like psychosomatic then?
It must
Yeah,
be.
I was just like, how how would something like that work?
It would almost have to
And-
be. I mean, that's the only scenario I can think of.
Yes. Yeah. If anyone has it come up, send it my way. I'd love to see it. I guess most of these settle once they start requesting psychiatric conditions anyway. But so for a loss of hearing, hearing connotes the ability to comprehend the spoken word for the purpose of communication with others. So the mere fact that a person is able to discern certain sounds or frequencies of sounds or at certain intensities doesn't prevent a finding of total loss of hearing if the person is unable to hear or comprehend spoken word, even when it's spoken very loudly. So as you can imagine, that came from a case where an individual said they had total hearing loss. The employer said, well, if you can hear something, not total loss. And the industrial commission took kind of a practical approach of, well, if you can't hear and communicate with someone who's speaking with you, then we'll consider that a total hearing loss. If the loss of vision or hearing stems from a problem in the brain stem with its functioning, then that loss of vision or hearing will not be awarded. Presumably, the difficulties from the brain stem functioning would be compensated in another way other than a loss of use award. And again, this is reflected in the idea that you have to have an ENT look at your hearing or an ophthalmologist look at your vision. They wouldn't be able to give an opinion about your brain stem functioning and whether the loss of vision or hearing has come from that either. All right. Up next, we have fingers. And I'll just show you, I'm working up a hearing and I have my legal pad here with doctor's opinions and where the fingers have decreased range of motion and where there may be ankylosis and how the finger's functioning. And this can get very complicated here with the fingers and where the loss has occurred. And so a loss of the phalange does not mean partial loss. Rather, it means severance near the joint. And so near leaves a lot of discretion with the commission, and hence the litigation and me having my file here with notes about where near the joint is occurring in my claim that I'm working on right now. And so the injured worker is entitled to an award for total loss of the use of finger when they suffer ankylosis or stiffness where they can't move their finger from the proximal interphalangeal joint. In other words, like the joint below the middle of the finger. And so if you fast forward a couple slides here, did I include just one slide that shows this diagram of the hand really big? And so this is it's a form C-196 from the Bureau of Workers' Compensation, and they break down the hand in pretty great detail. And so they show you the distal interphalangeal joint, the PIP joint, the MP joint, and they break down how much of an award is given for each portion of the finger where it is. And so what is key, what I have found to be key in looking at these kinds of claims and issues is to look at not the doctor's opinions about whether the person has lost use of their hand, their finger, or a portion of their hand and finger, but to really look at their exam notes and see what they are diagnosing essentially during their exam. So sometimes what I'll see is you'll have one doctor says this person lost 1/3 use of their finger due to ankylosis of their middle finger. And another doctor says they've lost 1/3. And then another doctor says they've lost their whole finger. So we have 3 doctors giving 3 different opinions about the extent to which someone has lost use of their fingers. But then when you go and look at their exam findings, they all have the same range of motion and stiffness findings in their exam notes. They just give a different characterization of those for their opinion because they know they're supposed to give a certain opinion to try to appease the injured worker, the employer, the bureau, whoever they're providing their report for. And so then you can go to opposing counsel for settlement, or you can go to your hearing and say, look, their exams are really the same. This should be a case where it's 2/3 of the lost finger, not 1 or a full or whatever. And so as you can see, the bureau gives the percentages, the number of weeks for each finger, depending on which joints are lost. This is a really handy guide. You can have the doctor, whether it's your doctor, you can give it to your doctor, say, where is the ankylosis occurring? They can write directly on this page. If you are agreeing with, if you're an employer agreeing with the injured worker, the self-insured claims guide says you can mark on here what you agree with and submit it with the bureau to accept the motion for loss of use in the hands and fingers. Just a very useful guide to know what's out there and figure out the medical terminology that the doctors are giving you too. If an injured worker has loss of 2 or more fingers, then the hearing officer may increase the award up to a loss of hand, as long as the amount of the, yes, okay. And so what this means is if an injured worker has loss of 2 full fingers, plus at least 1/3 of another hand, and they've lost the functionality to be able to perform their job, again, as noted in the job description, then a hearing officer has discretion to award loss of use of the whole hand. And so what may come up and what you may think is that if, let's say someone has 4 fingers that they've suffered an injury on, and they've lost 2/3 of 4 fingers, and that would be what, 8/3 or 2 2/3 fingers. So you may think, well, that's loss of 2 or more fingers. They should be entitled to an award up to the whole loss of hand. But the Industrial Commission, the Bureau, would disagree, because in that situation there is not a loss of 2 full fingers. It's 4 2/3, and so the hearing officer would not have the discretion to increase the award up to a loss of hand. I'll pause here. Are there any questions? Anything anyone finds interesting, wants to talk about?
I don't have any questions, and I don't see any in the chat.
Okay, great. Then I think then I have a slide about facial disfigurement next. And facial disfigurement is payable for an injury which results in serious facial or head disfigurement that impairs opportunity for future employment. The eligibility for a facial disfigurement award should be made at the point when the facial disfigurement has stabilized, and the award cannot exceed $10,000. And so there are a lot of factors to look at when determining whether an injured worker is eligible for this award and what the amount of the award should be. And again, a main consideration is how the facial disfigurement impacts the injured worker's ability to retain or secure employment. And so the medical evidence, the reviewing doctor or the treating physician should look at the shape, color, and location of any ulceration in the face, any depression or elevation in the face, the texture, if it's soft, hard, thin, smooth, rough, the attachment of any underlying bone, joint, muscles, or tissue, whether there's disfigurements based on nerve dysfunction or loss of range of motion. And then there is some specific guidance too on when maximum awards should be considered and likely given. And that's when there are third-degree burns exceeding 1% on or about the face of the head, where there's all skin grafting on the face or the head, where there's full thickness injuries resulting in the removal of multiple layers of skin on the head, and anything that could be considered a massive distortion of the face or its facial structure.
That sounds pretty subjective.
And it's, yes, very subjective. And again, I think it's interesting that those are some very litigation susceptible factors to consider. That seems like something that lawyers would love to sit down in front of a hearing officer and argue about. Well, 1, 2, and 3 go this way, 4, 5, and 6 go this way. But the amount of the maximum award is only $10,000. So when you look at the severity of the injuries that would be considered to be maximum facial disfigurement, like third-degree burns on the face of the head and grafting everywhere, like $10,000 doesn't seem like that extreme of a payment to make for someone who has gotten that severe of an injury at work. Anyone have any thoughts or opinions on that?
And if you're talking about severe enough to prevent future employment, I mean, there are so many arguments that can be made. With as many remote work from home opportunities as there are now, where you don't have to go anywhere, see anyone, be face to face with anyone, I can see a lot of arguments that can be made about that.
Yeah, and presumably if someone's unable to work anymore, they're filing for a PTD award too. And so they are incapable of any further employment. And so I guess this would just be an opportunity to, you already have that evidence, you're receiving PTD, and now you're getting a $10,000 award on top of that.
Interesting.
Or maybe you do this, maybe you try to get the facial disfigurement award first to get a ruling that you're incapable of finding employment before you move for PTD too.
Good strategy.
All right. Looking at my notes, I mean, I think I've gone through I think that's my last slide on my presentation, correct? Yes, and so I can talk more about amputations. I can talk more about any of this. Is there anything that anyone would rather talk about than just hear me continue to talk for a little bit?
Yeah, there is something that I'm curious about, and I don't have any specific questions, and I can't think of the specific cases. But I've seen over the last couple of years a lot of cases on loss of use awards where somebody's had a catastrophic injury and they were in the hospital, they were in a coma, on life support for 30 minutes for 2 days before they passed away, and that their surviving spouses are requesting loss of use awards for the arms and the legs and the vision and these kinds of things, because while they were in their comatose state, they couldn't move. They had no use of these body parts. And there's been several cases. Anything you'd like to talk about regarding that?
I guess first, let me ask you this. What do you have any opinions, or does anyone here have any opinions on if those awards, again, like I said, with the other things, does that seem like a fair award?
Yeah, I don't know if this is an opinion, but I think that, the cases that I can think of where I've seen decisions come out, it has been, I think the consensus has been that yeah, in some cases, the loss of use of vision or hearing was because of the spinal cord injury, and it wasn't because of the ears or the eyes. And so that wasn't appropriate, or sure, they didn't have any, they couldn't move their arms or legs because they were, paralyzed for that, a brief period of time before their passing. And I believe that the decisions I'm seeing are denying these loss of use requests. Am I thinking of that correctly?
I think so. I'm trying to think of a case name and find a specific case to pull up. But yes, I think that there is, again, like, there's significant talk about when a loss of use award is appropriate to bring. And so, for example, with, like you mentioned, the loss of use and hearing and sight from a death claim or something like that. Yes, the loss of use of the hearing or the seeing would not be from, I'm thinking of like a death claim where someone falls from a roof and suffers a brain injury and, like you said, goes to the hospital for X amount of time and couldn't use their sight, hearing, limbs, anything for that amount of time. And the loss of use for the hearing and sight isn't from something getting in the eye that an ophthalmologist would give an opinion on, or listening to something loud in your workplace for years that brings your hearing down. It's from like a brain injury or something that would have prevented that. And so I think that it would be appropriate for those awards to be denied. And I think too that I always come back to a fairness argument, or like, what's the purpose of this? And in a death claim, there are other ways for claimants or injured workers to get paid. And I understand and appreciate the ingenuity of trying to get an additional award on behalf of someone who suffered something catastrophic. But in the context of a compromise, I don't believe that these awards are designed to be used for that purpose either. I thought I had a case here pulled up about it, and I'm sure a judge that thought about it for several months before issuing a decision had something more eloquent to say than I do right now too.
And I'll just make the distinction that these cases are coming out of the 10th district because loss of
Yeah.
use would be a mandamus action rather than a right to participate issue.
You know, I'm not prepared with that right now. And so
Yeah, I'm
just not
sorry. I
gonna
didn't
speak
mean to
out of
put you
turn
on the
about it.
spot with that.
No, I appreciate it. I would much rather have a fun question to talk about that I have to come back to you later than not talk about what anyone's interested in. Yeah. What was the name of this case? Yeah, there was a case. It was there was a demolition worker who died hours after his workplace injury. He was in he died hours after there was an award given to the worker's widow for loss of his limbs, sight, and hearing in the period before his death. The doctor who reviewed the medical records testified that during that brief period, he had lost, use of those body parts, and they awarded 1,225 weeks of permanent partial disability benefits, or it was over $959,000. It was loss of use of both eyes, both ears, legs, and arms. And the 10th district upheld the benefits award. They found that for the short-term paralysis, it's irrelevant how many hours he survived to collect the award, because Ohio requires only that he would have been entitled to the award before he died. And so I think what the medical evidence showed is that if he had survived, he wouldn't have been able to use his arms, legs, eyes, or ears during his life. And so I think it was unique in the way that the doctor gave his opinion, and that the Industrial Commission accepted his opinion, that the 10th district did not vacate it. Walters, thank you. I'm looking at one where the claimant's name is Taluri, Taluri. That's the case that I pulled up. And the employee was Arberia. Do you have whoever commented, do you have experience with that Walters case?
Hi, this is Vicki Campbell from the Voorhees Law Firm. I should have clarified Walters. I believe, and I'm not sure of the specifics, but I think that case is used for the defense of the loss of use requests in a death claim. I'm not, but I'm not certain of exactly how it reads, but I believe that case is the case that's relied upon if a claimant's attorney requests a loss of use, in that short amount of time prior to an injured worker passing.
Okay. Interesting. I'll have to look that up.
I have it here. I'll send the link now. It's a 2024 case. So was it Vicky? You're on top of it.
Well, thank you. I like to say that, but we actually just had a case not that long ago involving this issue, and and the attorney argued that case
Okay.
Successfully?
successfully. Yes, it's on
Very
appeal
good.
now before an SHO, and I'm not. I don't believe the appeal's been set for hearing yet.
Okay.
Okay. So you may live with this one for a while still.
Yeah.
And so looking at the Walters case, I'm just pulled it up, and it looks like one way that it may be distinguished from the other case that I mentioned, the Telluri one, is that the hospital records from immediately following the incident just indicated that the decedent didn't sustain any injuries to his arms, legs, eyes, or ears. And so it seems like that may be a difference in the medical evidence that the injured worker provided in one case versus the other two. The specific things that the expert witness gave his opinion to.
Okay.
And so those would be, again, things that you want to look for in those expert reports when you're requesting them, when you're reviewing them. Interesting.
And in our case, the claimant, we believe, died right away, and his expert determined that he was from the time of the injury to the time of death, that he was alive for about 10 minutes. And
Okay.
so death benefits were, of course, paid out. But then his attorney came back requesting loss of use of his limbs, and I believe of his eyes. And our expert determined that there's no way of determining how long that the claimant would have lived. But he more than likely died right away. And we end up winning at the DHL.
Okay. Interesting. Well, if I get to join one of these again sometime in the future, I'll follow up with you and ask how that went.
Okay.
Or I'll
I'm
make
also-
a note for it. Yeah.
I'm also curious for your perspective on how a loss of use award would how that would play with a VSSR claim. If somebody perhaps alleged a VSSR for not having a guard, and they, as a result, their finger went into the machine and they lost their finger, how that loss of use award plays together with the VSSR.
In terms of so I guess a VSSR award, the hearing officer looks at the severity of the safety requirement that was violated, and gives an award between 15 and 50% of essentially the indemnity that's been paid in the claim. And so I would expect that and a VSSR award is designed to be a punishment against the employer for wrongdoing. And so I guess the question is whether a loss of use award would be considered in that percentage that would be given as a VSSR award then? Is that maybe specifically what you're asking?
Just, if somebody has, if the very fact of a loss of use award being granted in the claim, does that automatically help to prove their case for the VSSR? I guess is my
Sure. So
question in a nutshell.
okay. And so, sure. And so anytime that someone has lost a limb or they've lost use of a body part, I am on high alert for the possibility of a VSSR claim and vice versa. When I see there's a VSSR claim, I'm expecting that maybe their condition may worsen or not improve to a point where they're going to allege that they have loss of use of their finger. For example, just in 2 weeks at the end of this month, I have a claim going to hearing where the person bends metal and they put their hand in the machine as it was bending metal and it clamped down on their hand. And so he had a crushing injury to his left hand, and he said that the machine wasn't guarded properly to prevent against the injury. And so without going into the merits of the VSSR, I do not think that a loss of use award or an amputated body part should have any, I guess, evidentiary value in determining whether the employer did any wrongdoing in violating a safety requirement. I think that so in our specific case, it's bending metal. There's safety requirements around how the foot pedals work, how the light guards are to work, and make sure that all safety precautions are met, and that no employer can predict how negligent an employee may be when operating those items, and that if someone is negligent to the point where they lose a finger, hand, arm, etc., that doesn't mean that the employer should be liable for a VSSR award.
Right. Like we had a case where a gentleman reached around the guard and got his finger
What
cut
can you
off.
do?
And, that's not how they spun the mechanism of injury, but there were surveillance
Sure.
cameras within the shop. And there's video that shows him reach around the guard and the finger go flying through the air. Kind of gruesome, but.
Yeah. I think that if you're advising employers about where workers' comp claims and where exposure could go, when you have something like a crushing injury or where someone's been going to therapy and you're looking and seeing that their hand or their fingers are improving, it's good to make sure that they are aware that there could be ankylosis coming, there could be a loss of use award, and that could be something that they need to account for when considering their exposure and the claim going forward too. So oftentimes the VSSRs come in claims where there's more severe injury and a likelihood that a loss of use claim could be coming in down the line too.
Okay. We do have another question from Malachi.
Yeah, I'm not sure how this plays into like a loss of use claim, but say for example, if it was a workplace injury and like take for example, they like the example before with the pinky or well actually maybe not use the pinky because say for instance the entire hand or something like that where the injury to it basically it immobilizes it makes it so that they can never use it ever again. How would someone if someone applied for loss of use how would something like that maybe translate to, say for instance, Social Security disability? Like say if they no longer have use of that, is that like a claim that they could try to get, or they could try to get Social Security disability, or with Social Security disability, is that more limited to a disability that someone has, say from birth or as a child or something like that?
I don't have any expertise on Social Security disability. Anyone else in the room?
I know no experience at all with that.
No, okay.
I'm sorry.
Oh, no, that's okay.
Okay, well, we've got about 3 minutes left. Does anybody have any other questions or comments for John? Okay, well, then that being the case, we'll go ahead and wrap up for today. Thank you all for being here. Hi, Lisa, how are you? Nice to have you pop in. Lisa is from Ohio Reporting, correct?
That's correct. Yes. Thank you.
One of our sustaining members. Always nice to have you popping in.
It's great to be here. Great presentation. Thank you.
Yeah. I want to thank everyone for being here today, for taking time out of their day for this session. And I want to thank John for being with us and sharing his time and his expertise. This is a fascinating issue, and I don't think that we've had a presentation on loss of use awards in the past. So this was definitely a good one to have. So thank you, everybody. Have a great day.